Good morning to all enlightened and empowered women and men in this room. Let me share with you about gender and the law, or about gender justice, Philippine context. I'm going to read a prepared short article. Last December, Filipino women scored a significant victory in the passage by the Philippine Congress of the Responsible Parenthood and Reproductive Health, which is Republic Act 10354. The act, which is more popularly known as the Reproductive Health Law, adds to the list of pro-women legislations that have surmounted obstacles in and out of the halls of Congress. The Philippines, which pioneered the ratification of the CEDAW in Asia, has no shortage of laws, rules, and standards, a number of which formalize the equality of Filipino men and women. In fact, no less than the Philippine Constitution itself, and I quote, recognizes the role of women in nation building and shall ensure the fundamental equality before the law of women and men, unquote. In the field of leadership and political participation at present, women, although still a dismal minority, hold some key positions in the government. The Department of Justice, for example, is headed by a woman, Secretary Laila M. De Lima. In the incoming Congress, 5 out of 24 members of the Philippine Senate are women, and in the House of Representatives, Gabriela Women's Party was re-elected with 2 seats. A number of local politicians who have been elected or re-elected are also women, although it must be pointed out that most of them hailed from well-known or well-entrenched political families. The institution of the party list system in the House of Representatives, which reserves 20% of its total seats to elected party lists, has paved the way for the entry of the women's sector in Congress. Having women's party list lawmakers has greatly helped in the proactive legislation of laws that promote gender equality. In the fields of law and the judiciary, the Philippines has its first woman Chief Justice, Maria Lourdes A. Sereno, who is also the second youngest Chief Justice ever appointed at the age of 52. And since justices mandatorily retire at the age of 70, Chief Justice Sereno will serve as the Philippines' Chief Justice in the next 17 more years. Moreover, since 2007, there is a slight increase in the number of women in the judiciary. From 32% in 2007, it became 34% in 2010. And since more women are becoming lawyers, it is not unlikely that in the coming years, the percentage of women in the judiciary cannot but increase. The law profession, which was once predominantly a male enclave, now sees more women becoming lawyers. Statistics from the top 3 law schools in the country show that more women than men continue to enroll. Indeed, it can be said that the Philippines is a country where women can aspire to be lawyers, judges, or justices, legislators, and even a country president. But as will be shown shortly, much remains to be desired in many areas of development, particularly on the subject of gender justice. So since Sister Verada has shared that gender justice concept is a very difficult one to understand, for purposes of this paper, I provided an operational definition of gender justice, and it is proposed to cover 3 aspects which are by no means claimed to be exhaustive and fully reflective of the term. 1, I'm looking at the area of legislation, which refers to the legislation of laws that promote gender equality. 2, I'm looking at the area of law implementation, which refers to the implementation of laws that promote gender equality, those that have already been passed. And 3, I'm looking at the area of women's access to courts and judicial processes. Now, the areas of concern with respect to legislation. Women's movements and activists well know that the work does not end in the passage of laws. Aside from the fact that the Philippines is still wanting in some key legislations prescribed in the CEDAW, some old and not so old laws remain to bear negative effect on women's lives or are lacking in ample protection for women. The concrete examples are expressed by way of the following proposals. 1. Legislate measures or remedies for migrant women victims of violence outside the country. Migrant sector is one of the most neglected sectors of Philippine society. The government's unabated promotion of the labor export policy continues to drive women out of the country and away from their families. Many of them suffer sexual assaults from their foreign employers. In the Women's Legal and Human Rights Bureau Inc.'s submission to the UPR in 2011, it wrote, and I quote, "The Philippine government is complicit in its violations of Filipino women migrants' rights under the CEDAW and the General Recommendation 26 because of its indiscriminate and deliberate promotion of labor migration, targeting large number of women to fill the high demand, especially for household service work, though fully aware of the unregulated conditions of work, history of abuse, vulnerabilities of high demand for work in the entertainment industry, has the effect of impairing the recognition, employment, and exercise by women of their rights. On account of the principle of territoriality, there exists no available remedies under Philippine criminal laws for migrant women victims of violence when the act is committed abroad. If and when the woman victim decides to pursue the case abroad, she is left with little or no financial and legal assistance from the Philippine government. Therefore, this calls for legislation that enumerates the state's concrete commitments and forms of assistance to migrant women victims so that the migrant women can positively assert these entitlements under a law. Number 2, pass a divorce law. I quote, "Infidelity, violence, abandonment, and arbitrary dissolution of marriage are male strategies to informally end and do away with the responsibilities and commitments in marriage. Society and culture have tolerated these acts. The absence of divorce law in this country affects more women than men because more women suffer from failed marriages due to their economic and many other forms of disempowerment. The absence of a divorce law is detrimental as it forces individuals to remain in irreparable relationships, exposes women and children to violence. Divorce can be a remedy to this situation and an enabling mechanism for individuals to pursue their well-being and development." Unquote. Gabriela Women's Party is at the forefront of the advocacy for the passage of a divorce law in the country. But as in the case of the reproductive health law, the Catholic Church poses the staunchest opposition to the passage of the divorce bill. It brands the bill anti-family, anti-church, anti-life, anti-God, and hence a death bill. The conservative leadership in the Catholic Church muddles the issues by imputing attributes to the bill that are not found therein. Next, we recommend that there be a further amendment to the anti-rape law of 1997. The existing definition of rape fails to positively state that lack of consent must be defined from the victim's perspective. This opened the door for judges and justices to come up with a conflicting and often gender-insensitive definition of consent in rape cases. I quote, "Rape and sexual harassment survivors face grave difficulties in court. The most painful experience of sexual assault survivor in court is being blamed for the sexual abuse she suffered and eventually losing her case because the judge and or justices failed to appreciate her lack of consent based on the woman's perspective. In some cases, courts fail to appreciate circumstances that prove lack of consent, including the effect of alcohol on the woman or means the woman employed to evade the sexual assault, such as expressing a desire to go home, constantly moving away from the perpetrator, keeping ties closed, or not resisting due to fear of being beaten or killed." Unquote. Some decisions have continued to picture a rapeable woman, have based resistance or consent on the strength or lack thereof employed by the victim, have used against women victims the amount of time they allowed to lapse before filing a formal complaint, and many others. As pointed out, I quote, "The Supreme Court may well be partly liable, as many of the principles trial judges use to justify dismissal or acquittals premised on such erroneous assumptions are based on Supreme Court decisions. The Philippine anti-rape law and how it is interpreted by our Supreme Court is full of contradictions that after 30 years of ratification to the CEDAW, myths and misconceptions on rape cases and discriminatory assumptions in jurisprudence continue to place rape victims at a legal disadvantage and significantly reduce their chances of obtaining redress for the violations they suffered, unquote. Although efforts to promote gender sensitivity within the judiciary have had positive impacts, rape victims will be amply and surely protected against gender-insensitive or gender-blind interpretations via the amendment of the definition of rape in order to include a definition of lack of consent from the victim's perspective. The proposal is to repeal the crime of adultery and concubinage as presently defined under our revised penal code. I quote, "The institution of marriage and the family rests on a monogamous and subordinate female and a naturally promiscuous and dominant male. But if society is to uphold marriage and family life and at the same time allow men to indulge in their sexual urges, it had to find ways to gratify the latter without sacrificing the former. The solution that emerged was to have a group of women, prostitutes and mistresses, to provide the sexual and other needs that the male is unable to satisfy in a conventional marital relationship. The solution found support in law, which made the distinction between a husband's concubinage under scandalous circumstances and a wife's simple adultery as ground for separation. The ideology of male sexual needs thus came to justify the double standard, the practice of keeping mistresses and the prostitution of women. What needs for a woman to be convicted of a crime of adultery is only one simple adultery is only one sexual act. But for the man to be convicted of concubinage, it has to be sexual act in circumstances that's called scandalous under the law, and there is a definition of what scandalous circumstance is. So we want this repealed because it provides for a double standard. Next, pass a law and promulgate rules on electronic violence against women, or EVOW, or ICT-related VOW. There is a need to update our laws in order to address the fast-changing realities and means of commission of violence against women. While technology had many positive impacts in our lives, it is also continuously being used to inflict harm and violence against women. The effect is not only fast and widespread, but borderless and quite difficult to detect. Now, on the aspect of law implementation, we propose that there be an assessment of the impact of assistance to women victims of sexual assault and institute additional measures if necessary. We have the Rape Victims Assistance Law and the implementing rules and regulations on the Anti-VAUC Law, or Anti-Violence Against Women and Children Law. But there is a need to assess the impact of assistance to women victims of sexual assault. Indeed, I quote, "It does not end with enacting legislations which spell women's rights in cases of abuse. There is need to look into how the available remedies are able to respond in practice and reality to women who suffer from violence and abuse," unquote. We also propose that the reproductive health law be fully implemented. The law, which should have taken effect on March 31, is a subject of a 120-day status quo anti-order of our Supreme Court. There will be oral arguments next month. So it's on hold. The implementation is on hold. Next, we propose that the government ensures that the gender and development budget trickles down to women who need the reforms most. On women's access to courts, we propose that there be more measures towards making the court accessible to women and members of other marginalized sectors of society. Access to courts or access to justice remains a serious problem of the Philippine judicial system. Courts and judicial processes as a whole are viewed as inefficient, corrupt, and not easily accessed by those who have no money to spend for long litigations. It will perhaps require an overhauling of the judicial system in order to make it efficient, free from corruption, and accessible to all. But in any efforts towards making the legal and judicial system accessible to women, the balance must be tilted in favor of the women, because for over so many decades, I quote, the legal system has reposed greater power, authority, and opportunity in men in general, unquote. There should be an engendering of the judiciary even more. In a speech by our former Chief Justice, he reported that the Supreme Court had been making efforts to engender the judiciary to its citizens and the litigants, and yet many women who suffer violence still choose to remain silent for fear of reliving their experience in the presence of an insensitive case investigator, prosecutor, lawyer, court staff, and judge. A more engendered and effective judiciary will encourage victims to speak out. Further promote gender sensitivity and gender justice in written decisions. We have the Gender Justice Awards, which was launched in 2004. And the first awardee is Judge Maria Nympha Sitaka of the Regional Trial Court of one of our cities. This is a beautiful decision that she wrote, and I quote, "This is opposed to some decisions that prescribe what a rapeable woman is." She wrote, "An abundance of words is not required for the court to see what the private complainant went through." This is a rape case. "The medical certificate issued by the municipal health officer graphically corroborates what the child has been unable to put into words. Accused lamely says that the mother who resents him must have coached the child into fabricating the accusations against him. Would a mother deliberately expose her child to the difficulty of a court examination and her private parts examined just to get even with her father-in-law for a resentment, imagined or real? Accused's contention is difficult to believe. It is likewise settled jurisprudence that no mother would publicly expose a young daughter's dishonor for the purpose of satisfying some evil motive against the accused. As opposed to decisions that investigate whether the woman used enough resistance as against the perpetrator, or as opposed to decisions that dismiss the case for rape based on technicality because the victim was unable to put into words what she had to go through. And we have rules on evidence, and lawyers use that to effectively bar the victim from retelling the story in court. But if you have a judge who is gender sensitive and who understands the power play, then she can actually decide the cases not just on the basis of law but on the basis of studies that victims react differently, especially to such violation as a sexual assault. The judiciary must proliferate gender sensitive decisions, and more importantly, must encourage and promote judges to take gender into consideration in deciding cases. On this aspect as well, lastly, promote gender education amongst law students and lawyers. Now, the challenges and strategies. The branding of women's advocates and activists as leftist rebels by the state and its agents persists under the present government. Women who work for gender justice in the greater context of social equality and state accountability continue to face threats and harassments and limitations in their fields of work. From the conservatives within the church and other critics, these women also run the risk of being labeled or are actually labeled as agents of the devil or of the dark forces. And yet, these nameless and countless women continue to persist and struggle for equality and gender justice. They are in the halls of Congress, in the streets, in the classrooms, in the courtrooms, in the academe, in the fields, and in the communities. For sure, we will continue to assert the women's rights, call on the state to its duties to women and all citizens, rally in the streets or engage in mass actions, conduct researches, write articles, legal briefs, and decisions that will shape jurisprudence towards the attainment of gender justice, propose and lobby for legislations, acts as ombudswomen against corruption and abuses, and strengthen linkages and international solidarity. Thank you.